Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the Fourth Court of Appeals, District of Texas is now open pursuant to call.
You may be seated. Good morning. And Mr. Weber, I can't see you over there, but I know you're there. The court welcomes you. The panel this morning, I will be presiding, and to my right, I've got Justice McCray, to my left, Justice Mesa, and we welcome you to the Fourth Court. At this time, I'm going to call the case and ask for announcements. Court calls 424-380 CV, Pryor Legacy Properties LLC versus Ranches at Overhills Property Owners Association, Inc. Stephanie Hughes on behalf of Ranches at Overhills Property Owners Association. Thank you very much. And you may proceed, Mr. Webb.
Thank you, Justice Rios. May it please the court. I represent the appellant, which is Pryor Legacy Properties in this matter. The defendant's principals are here in the courtroom this morning, and that would be Ms. Nevels, Ms. Thomas, and Ms. Terry, and they're seated behind me to my left. What is being sought in this appeal is reversal of the order granting the plaintiff's motion for summary judgment and remand to the trial court to proceed in light of the determinations to be made by the Honorable Court of Appeals. The appeal primarily concerns whether a homeowners association may offer a service to property owners to review prospective improvements to the owner's property, charge and receive a fee for providing that service, ultimately provide an approval, and once the improvement is then purchased and is in the process of being constructed, accuse the owner of violating the covenants and demanding removal of that previously approved improvement. I've provided some exhibits to the court. They're not evidence in this matter. They're only for purposes of clarifying what this structure is and what it's not. First diagram is of a commonly known double-wide mobile home. It's architecturally uninteresting. There's no doubt that it does not belong in a community along the lines of the Appellee community, but it's also nothing to do with this case. This is not the type of structure that's involved. The type of structure that's involved is the one that's depicted in the second photograph, and that's the one that I presented to the court just now. It is got significant architectural interest. Yes, it is built off-site, and the modules are then brought onto the property and assembled on site. However, it is architecturally appropriate. It is architecturally interesting. And as you'll see from argument this morning, I don't think that the fact that it happened to be constructed off-site to any degree should have anything to do with the legal principles involved in this type of dispute going forward. And that's what I hope to convince the court of today. And then finally, my own personal favorite, and this is what we could be dealing with in the future. This is referenced in our reply brief at page 13 in the footnote. This is known as the RK1. It's designed by a very famous architect named Ray Kappe, K-A-P-P-E. Mr. Kappe has since passed away, but this is a structure that was built in modules inside a factory using computer numeric controlled equipment. So in other words, you don't have guys out on the property sawing after measuring tapes. It's computers that cut all this stuff. It's put together in an environmentally controlled factory with all the tolerances that computers can provide. And then it's snapped together in modules at the site once it's delivered to the property. This is the future of residential construction, and it is the type of structure that today's case can have a significant impact upon. It also happens to be a favorite structure of mine that I've been sort of lusting after for about the last 10 years. At any rate, the appellant purchased some real estate in Gillespie County, Texas, in the Appellee subdivision. The appellant intended to use that property for family gatherings and to have multiple structures on there. Originally, the intent was to have 3, one being a barn dominium and 2 being the smart cottage that's depicted on the floor here. And they made application to build those 3 structures. There was several months, almost a year of discussion back and forth between appellant's representatives and appellee's representatives. In fact, the application had been made twice, first to the developer of the subdivision who approved all the plans that were anticipated. But then once the Architectural Control Committee came into existence, this was a very new subdivision, the plans were submitted once again to the Architectural Control Committee. There was approximately 8 months of additional discussion, considerations, negotiations going back and forth between the parties. And ultimately, an approval was granted for those plans as well. What then happened is the appellant went and actually purchased the structure that's depicted on the second exhibit, the one that's on the floor. And they began to have it delivered to the property and assembled. The Appellee's representatives saw that this structure was coming in the form of modules, on the back of trucks kind of thing, and went to the courthouse, filed a lawsuit, and I became involved shortly after that.
Mr. Weber, can you talk to us about the Texas Occupations Code and how it defines mobile home and manufactured home, and what are we to do with those definitions?
Yes, Justice Meza. There was actually a lot of political intrigue that involved the Occupations Code and those definitions, and the industry was involved in that a number of years ago. What happened was, as soldiers were coming back from overseas at the end of World War II, they needed places to live. And the homes couldn't be built fast enough, but these mobile homes could be. They were ugly, but they could be built very quickly. And so they started being put together and people were buying them and moving into them, and you had mobile home developments start to exist. Well, because they weren't architecturally interesting, shall we say, various restrictive covenants that were written began to prohibit them. It wasn't the kind of structure that was desired in a custom home subdivision for obvious reasons, and appropriately so. And so so these types of structures began to be prohibited in covenants. The industry that made these mobile homes, though, didn't really like the fact that their structures were being prohibited. So they sought the legislature's assistance to change the definition. And that's when the legislature said, okay, mobile homes are going to be things that were built prior to, and I'm sorry, I forget the exact. 1976, thank you. And anything that's built after that is going to be called a modular home or a manufactured home. And the intent, I think, and some of the scholarly writings in this seem to suggest as well, is that by changing the definition, the covenant said no mobile homes. Well, we're not going to call them mobile homes anymore. We're going to change the definition and therefore allow them. It didn't work. And so, and I don't think that's an appropriate standard anyway. It was clearly a legislative maneuver. It should never have been done. The real issue is set out in my footnote on page 13 of the reply brief. And what that is it shouldn't matter where the structure was built. The only thing that should matter is what the structure looks like. Is it architecturally appropriate? And I'll concede, the smart cottage probably on its own still would not have been architecturally appropriate in the case at Bar, for the ranches at Overhills subdivision. However, the barn dominium that is not objected to and that was also built on the property was architecturally appropriate. These were ancillary buildings. And as ancillary buildings, they were perfectly appropriate. And so the real question here is, is that a structure that doesn't look right for the circumstance? And I don't think that a reasonable determination could be said that the structure doesn't look appropriate. Had that same structure been built on site using what they call sticks, the 2x4s and the individual panels of roofing and the individual panels of wallboard, that structure probably would not be before the court today. The only reason that the appellee was able to raise a fuss is because it was built off-site.
So to the traditional motion for summary judgment on the breach of contract, what evidence did you raise to overcome what the court did?
We tried to establish basically what I'm telling the Court of Appeals this morning, and that the definition of these things has to change. But the biggest factor that we tried to raise was the Estoppel factor. And the Estoppel factor being this was approved. What was brought onto the property was exactly the same as what was approved. And it's the classic definition of Estoppel. This is the kind of thing that you might find in a law school horn book, where somebody seeks approval for something, that approval is given, a change of position is made, and that change of position was made obviously when Pryor Legacy Properties went to the seller of the smart cottage and paid nearly $180,000 for it. And then after all that was done, after that change of position and reliance on the approval had occurred, then they bring the structure onto the property and it's, oh my gosh, we can't have this here because it was manufactured someplace else. And so I tried to convince the trial court that estoppel should apply. And apparently I was just unsuccessful in doing that. I think that's really the strongest issue in the case. And that's the one that I would suggest needs the greatest attention by the Court of Appeals.
And that's on the no evidence motion for summary judgment as to your affirmative defenses of estoppel, promissory estoppel.
I'm sorry, Justice Mason, I don't recall what part of that response it went to, but I do recall that we raised the estoppel issue.
Can you talk to us about the waiver issue? that you
The
raised?
waiver issue, I think, is related, and that is once that approval had been given, then that waives any objection that the homeowners association may have had to the structure that was being on the property or being brought onto the property, unless the structure being brought onto the property was not materially or substantially similar to that which had been approved.
Do you have any case law that we can look at that says that waiver is very specific to the party seeking, for example, in your case, to Pryor Legacy? As I read the case law, it talks about waiving, the association waiving restrictions. They have to look at really the neighborhood as a whole and other violations to determine if the association is waived.
Actually, Justice Rios, that was my case that established that. That was the Pebble Beach versus Shearer case. And I don't recall the exact percentage that where you sort of tumped over the edge and then had waiver. That's not exactly applicable to the case at bar this morning for one particular reason, and that is that Ranches at Overhills is such a new subdivision that we didn't have an opportunity to get to that point of where we tumped over the edge of that. I think it was 13 or 14% threshold that was established by this court, actually, in that case that I had, the Pebble Beach versus Shearer case. So I think waiver still applies because of the distinct approval that had been given. They waived their ability to object to that structure, irrespective of where it was built. They were already familiar with what it was going to look like. The only thing that they really have to fuss about is where it was built, and I think that that's a distinction without a difference. At least it ought not to be any
So
longer.
what should we do? There's a non-waiver clause in this declaration, is that right?
There is, Your Honor.
Okay, and non-waiver clauses are ineffective only if there's a complete abandonment of all restrictions. And you're saying this is a new neighborhood because the association is, as we all know, wasn't even created until, a few steps into this process.
Right.
So what are we to do with this non-waiver clause that's in the declaration?
Well, like I said, waiver is not really the strongest argument. I think the argument is the estoppel argument. And no waiver really was even necessary here, just like no variance was necessary. The Appellee suggests that a variance had to be obtained. Well, a variance is to allow something that would otherwise not be allowed. That's not what this is. This is something that was in fact allowed because at least the appellants believed that they were submitting something for approval that did not violate the covenants. And upon reviewing what it looked like, the appellees obviously took the position that it didn't violate the covenants either. So accordingly, they approved it. No variance was required. So the stronger argument really is not so much one of waiver as it is estoppel. The association approved that structure. The structure that was brought on was materially similar to what had been approved. Nobody's suggesting otherwise. And so once it was approved, and once the appellants made that $180,000 investment to acquire it, signed the contract and had it delivered, it's too late to say, oh, wait a second, this isn't what we thought it was going to be. You had that chance. There was an 8-month opportunity for the appellee to make whatever degree of inquiry they wanted to make about where's this being built and how's it being built, and there were discussions that went on during that whole time.
So would you also address, and I'm sorry, because I know we're limited on time.
Of course.
want to make sure we get to other points. You also asserted a counterclaim under the Uniform Declaratory Judgments Act.
We did, Your Honor.
And I know that, it's been challenged and whether it's a cognizable claim or not. Because the case law in the Supreme Court and BPH tells us that a party cannot simply restate a defense. Because the issue here is whether it is a mobile home or is not, correct? And your counterclaim in the form of a declaratory judgment is asking for the court to state that it wasn't. So is that not just a mere restatement of your defense?
It might be. This was explained to me years ago as essentially an inferential rebuttal defense. However, I am familiar with a case, once again, that I had before this court. It'll come to me in just a moment. It was a case where a gentleman and a lady who were dating had adjoining condominiums. They wished to put a doorway in between, and the association refused to allow them to do so. We tried it in front of the district court here in Bexar County. The jury decided in favor of my clients, and the judge issued a JNOV. We did seek a declaratory judgment in that matter. The appellee in that case, we sought to restore the jury's verdict, came before the fourth court to do that. Rankin and Farrer versus Covington Oaks is the name of that case. In that case, this court specifically stated that a declaratory judgment is an appropriate mechanism for determining issues involved in a homeowners association restrictive covenant case. So it was basically under that theory that I figured if there were any issues that weren't resolved by the plaintiff's pleadings, that the declaratory judgment would kind of serve as a catch-all for whatever other issues might need to be resolved to resolve this case. And it was in reliance on that Rankin and Farrer versus Covington Oaks matter.
Mr. Weber, during the hearing at the trial level, I believe the HOA made claims that, well, hey, we rely on the homeowner who's applying for these, permissions to give us full and complete information. Is there something that the homeowner Pryor could have done to not be in this?
I don't think so, Justice Meza, because of the circumstances of this case. They made inquiry to the seller of the smart cottage. Is this a mobile home? Because we're not allowed to have mobile homes. And that seller told them, no, it's not a mobile home. It's a modular home, or it's a manufactured home. And so you're not in violation of the covenants by acquiring this structure. And so they believed that they were seeking approval of something that was not in violation of the covenants. Had they thought it was in violation, they wouldn't have even made the application in the first place. That's part of what I'm asking the court to do in this case, is to make clear who has that duty. And it strikes me that if that duty is not put upon the party that has the authority to make the determination, then why bother having them there? Instead, just let the owner of the property put whatever they want to put on the property. And if it doesn't comply, they can be ordered to remove it later on. Obviously, that's not a very good use of resources. And so that's why we have this pre-approval process first. But if we're going to have the pre-approval process, well, then we have to honor it. We can't let folks approve something, have other persons rely on that approval, and then have the approving party change their mind later on.
But Mr. Weber, let me ask you, in the record, there's an email dated September 30th, 2021 from Lois Terry, which states, in response to your instructions sent for architectural review, dated August 31st, 2021, I additionally submit our overall site plan for your review. The plan is a phase build. As such, we do not have complete drawing packages at this time, and will purchase full phase development and drawing documentation upon approval of the plan. Additionally, we will require a non-disclosure agreement to release further drawing documentation. So how can the association's approval be anything more than a tentative approval of the floor plans, given that is all that you submitted and given that you requested approval in order to proceed to get more detailed plans?
Justice McCray, I believe those more detailed plans were in fact provided later. And that the approval of the plans was subsequent to the provision of those additional materials. The request for the confidentiality provision had to do with the seller of the smart cottage not wanting to get their trade secrets about, manufacturing processes and design and that kind of thing, made something that was necessarily public information. They wish to keep that information privileged, and so that was the reason that request had been made early on in the proceedings.
When were those more detailed plans submitted?
It was part of the process some number of months later, once those plans were obtained, and it was, like I said, there was about an 8-month period after the second submittal, after the Architectural Control Committee that had been formed. There was about an 8-month period where information went back and forth, and that's when these additional plans were submitted. On top of that, Justice McCray, there's a danger in making incremental approvals. These associations ought to be made to make clear that, I'm sorry, you do not have an approval of any sort until you get an actual approval. Because otherwise it results in laypersons who aren't familiar with this process saying, oh, I have gotten approval of some sort, and they don't know what they can rely on. I have suggested to my own homeowners association clients that they not issue any kind of incremental approval or tentative approval. And they make real clear that you're not approved until you are actually approved.
Time is up. You may wrap up.
Thank you. Actually, I'll save the rest of the time, I guess, for the rebuttal.
Yeah.
Thank you, Justice.
You're welcome. Ms. Hughes? You have 20 minutes.
Good morning. May it please the court. The trial court properly granted Ranches at Overhills summary judgment motion, and its decision should be affirmed. This is a straightforward breach of contract case where the relevant facts are undisputed and the legal issues are well established by binding precedent. Here, the structure at issue is a mobile home, and mobile homes are expressly prohibited by the declaration. Here, the declaration is the contract. It's undisputed that the declaration prohibits mobile homes. It's undisputed that the structure placed on Pryor's lot constitutes a manufactured home. The record reflects that the sales order confirmation refers to it as a manufactured home. It satisfies all the requirements laid out in the Texas Occupation Code as a manufactured home. It was constructed off-site. It was delivered on a chassis, delivered in one or more pieces, and installed on the property. And I think there was a little bit of confusion with reference to modular homes when Mr. Weber was speaking, and that's not an issue here. Modular homes are constructed to an entirely different standard. The determining factor between the mobile and manufactured is they're built to HUD code standards. Modular homes are built to, I believe it's the Industrial Housing Act, have its own requirements, and they're built to site build standards. And it's well established by the Texas Supreme Court and this court that a manufactured home constitutes a mobile home under the terms plain and ordinary meaning. Mr. Weber referenced the Pebble Beach case, where this court and Mr. Weber successfully argued that a mobile home and a manufactured home were the same for purposes of deed restrictions. And I'm kind of surprised we're hearing this argument today because Mr. Weber appeared to concede that the terms were one and the same at the summary judgment hearing. But in any event, the Texas law is clear. The Supreme Court agreed in Wilmoth versus Wilcox. It held that the terms mobile home and manufactured home were synonymous for purposes of deed restrictions.
Ms. Hughes, in both of those cases, it looks like the court heavily relied on the intent of the people drafting those covenants. What evidence at the trial level did you all produce as to the intent in drafting the declaration?
So I think our argument was focused on, this is a contract, and contracts or restrictive covenants are interpreted the same as contracts. That's well settled Texas law. And when a term isn't defined, you have to look to the terms plain and ordinary meaning. And all of these cases held that despite the time period, it's all one and the same, whether it's a trailer, a mobile home, a manufactured home. And I think one of the court's decisions referenced how You know, an association can't anticipate what term could be used later on. The terms continue to change. Manufacturers are getting very creative now, and I'm hearing terms such as cabins and cottages. So they couldn't possibly anticipate what these structures would be referred to, I guess, in the future.
And your declarations include cabins, I think.
It says cabins are okay,
Mhm.
but I have seen manufactured homes referred to as cabins, but then when you really look into it.
So in this case, this is a little bit different from Wilmouth, because in Wilmouth, I think there was actually testimony from the actual people who sat down to draft the declaration.
That's correct.
All right.
Therefore, Pryor's manufactured home constitutes a mobile home as a matter of law. And secondly, the only way Pryor would have been permitted to place this mobile home on its property is through a written variance. Now, the declaration is unambiguously clear in that it provides non-compliant conditions shall be allowed to exist on a lot only upon the owner obtaining a written variance in accordance with the applicable provisions herein. Now, Pryor claims he doesn't know what this means, but again, the plain and ordinary meaning of the term vary means to modify. And a variance is simply a modification as to a particular homeowner with respect to the restrictive covenants. Pryor even uses the same terminology in his brief. He references that this approval was actually a variance / modification. It's page 47. And I think the important part of this.
Excuse me, can you address the issue that potentially the HOA waived your right to enforce the declaration as to the cottage that was approved, that was brought up in the
Certainly.
appellant's briefs?
So I think it may have been Justice Rios that brought this up. The declaration does contain a non-waiver provision. No owner has ever attempted to place a mobile home. No one's ever asked to do it. It is a new community, but it hasn't happened. And if that's not the determining factor, the next is, has there been a complete abandonment? The HOA is functioning, it holds meetings, collects assessments, enforces its deed restrictions. So I think that argument fails. But I think what's continuously glossed over in Pryor's arguments is that this was never disclosed. The only things that were submitted were these two floor plans, the floor plan of the barn dominium and the floor plan of this proposed guest house. There was nothing on there that would have given rise or suspicion that this was actually a prefabricated manufactured home.
Were there subsequent emails describing that?
There were, and I believe the site plan that was referenced was provided kind of showing rectangles where each structure was going to go to comply with the setback lines. But there was never a brochure, a photo, the name of the manufacturer. The association was never aware that this was something purchased. In fact, some of these email exchanges, Pryor uses terms such as, can we construct the guest house? Kind of implying that it would be site-built. So the association had no reason to think that this wasn't going to be a site-built home.
Was there any communication between Oak Creek Homes and the association?
There was after the mobile home was placed. I had some back and forth personally with a representative. We were trying to gather more information. I think there's some emails in the record where he states this cannot be turned into a modular home. And there was an attempt to see if perhaps the structure could be converted to not be a violation, but it was ultimately determined that that just couldn't be done without either a variance. And so the only method for obtaining a variance within the declaration, it states that it has to be done within the applicable provisions herein. That means we have to look to the declaration for this procedure. So your typical HOA will have ACC authority, and it will kind of provide a procedure, and I guess outlining what discretion that committee has to grant a variance. Here, there is no ACC authority. So we have to look to the only provision of the declaration that discusses or references modifications is this amendment section, which requires a vote of the community, 75%. And it must be in a written writing recorded with the county, in Gillespie County. So it's undisputed that no variance modifying the declaration ever took place. Pryor is relying on this approval letter that never references mobile home whatsoever. So in response to some of his equitable arguments, not only did they suffer fundamental factual flaws, but they suffer legal flaws as well. The first I want to address the factual flaws. Every one of his arguments are based on this February 2022 letter, this approval. It's from the association, it's signed by the management company, the president of the board, and this was issued in response to Pryor's voluntary submission of these two floor plans, the barn dominium and the proposed guest house. But what does this letter really say or do? First, it says, and it's on 716 in the record if you're interested in referencing. It states that the single-family barn dominium complies with the setback requirements and the minimum square footage requirements. And then it approved the accompanying guest house with respect to setbacks, minimum square footage. But then it also states, and this is important, it must be built and maintained in the same fashion as the single-family residence.
What does that mean?
So while that's not determined or not defined in the declaration, one has to interpret that it's site built. I don't think there's any dispute that something prefabricated and delivered is not built in the same fashion as a site-built barn dominium. Probably could be clearer. I think what it's not, or I guess it must be more like a barn dominium than a prefabricated home, was the association's interpretation of that.
If we take that interpretation, are we not extending or adding to that?
Right.
We'd kind of be coming up with our own, right?
Well, so when I think about this provision, we're confined to this declaration, and this declaration is not your typical pages and pages you'd find in the city or suburbs. We're limited to kind of this universe of facts and definitions. And so, all structures have walls, all structures have a roof. So it's got to be more than that. But it doesn't go into too much detail. So I think the manner in which it's constructed is probably, since it already prohibits mobile homes, it's likely that it must be either in the same style, built in the same fashion, site built is what our interpretation was of that.
But can single-family dwellings be manufactured off-site? I mean,
But I think if that was inconsistent with the prohibition on mobile homes, it would contradict each other.
let's jump to negligence. Pryor asserted negligence as a counterclaim. And I think give us your position on that. You're saying, I think it's your position, the association's position, that it only has a duty to enforce the declaration and nothing more.
That's right. So
So
again,
first, before you start, can you cite to any authority that says that? That is the association's only
With-
duty in one of these review processes.
so I don't think there's a case, or I'm not aware of one that speaks to this specific issue where there is no, where it's speaking to duty, because I think this goes back to well-known, I think Ski Masters and Polarisik versus Emens, where the court holds that when construing restrictive covenants, appellate courts apply general rules of contract construction. And so this duty, I mean, this is trying to add a tort claim or principles of tort to what we're confined to as a breach of contract. And courts have held, believe it's Ideal Lease versus Amico, held that, a court cannot expand a party's rights or responsibilities. So while Pryor didn't have a duty to provide this information, the association did not have a duty to require it. So unlike, you see cases where improvements are made on lots without obtaining pre-approval first. If that had happened here and it was in compliance, it would have been no issue. Owners are free to do that. This approval, I guess, process is really offered because owners want that. Owners want to know that their plans are going to comply and there's no issues. So it's really designed as kind of a checklist to identify red flags. And the management company or the board can kind of direct the owner and say, oh, this isn't going to comply. So
Because in this case, the plan was approved, right? The floor plan that
the
was
floor plan
submitted.
was approved, but the mobile home wasn't approved as they weren't aware of a mobile home. But they couldn't have approved it. It couldn't have been approved without a variance, and a variance required a vote of the members. So even if the management company or the board had said, you can have a mobile home, it would have been of no effect. It would have been a nullity.
Was there any material fact issue that was raised as to the promissory estoppel? Because I don't think the association was clear in what element of that claim there was no evidence for.
Our claim, with respect to the actual or constructive knowledge.
Mhm.
So in order to prove a claim of estoppel, Pryor needed to prove that it reasonably relied on this approval letter. But first, as a party to this contract, the declaration, Pryor's charged with knowledge and understanding of that contract's terms, which means he understood that the only way a mobile home would have been permitted is through a variance, a vote of its members. So on its face, it couldn't have relied on this. But secondly, the association didn't make any false statement or concealment. There's nothing in this approval letter that was inaccurate. It said, it's consistent with the setback requirements, the minimum square footage, and consistent with must be built and maintained in the same fashion as the primary residence. There was nothing, I believe the Pebble Beach case, the court held that the owner must have shown deception by the association, which there was no deception here. I mean, I think you could make the argument the other way around, but that's irrelevant here. The intent doesn't matter. The fact is this was a breach of contract, no mobile homes. A mobile home was placed without a variance. So Pryor, as we discussed, the provision about being built and maintained in the same fashion is ignored. And Pryor's trying to argue that this letter constitutes approval. And because of that, the association is therefore stopped from enforcing this prohibition on mobile homes. But as I mentioned earlier, I don't think there's any dispute that a site built for condominium and a prefabricated manufactured home are not built in the same manner. Pryor also tries to focus on the language in this approval letter that states plans are submitted or approved as submitted and no deviation of these plans is allowed. But I think this suggests that the language is some type of blanket approval. As long as it somehow depicts what's depicted in the floor plan, no matter how it was built. So I don't think that can logically constitute approval. But legally, these arguments are also flawed. As I discussed, the only method that the mobile home could have been permitted is through a variance, modifying the declaration's prohibition as to Pryor's specific lot. As we discussed, we're bound by this contract. Pryor's charged with the understanding of its terms. Whether he read the contract, the declaration, and understood what the provision meant, he's charged with the knowing of it. And going back to the estoppel, his arguments really boil down to two things: that he reasonably believed this letter was sufficient to permit a mobile home, and he reasonably relied on it. But in Advent Trust Company versus Hyder, a party asserting any form of estoppel must have reasonably relied on the defendant's misrepresentations or concealment. And I think putting aside that there's no misrepresentation or concealment at all, Pryor couldn't have relied on that letter. As a party to the contract, again, he's charged with understanding the procedure for obtaining a variance. But then again, if the alleged misrepresentation relates to the contract, a party can't justifiably rely on that if it contradicts the terms of the contract. So neither the president or the management company had the authority to grant approval of a mobile home, and such approval would be of no effect.
So Ms. Hughes, I think Pryor's position is that after they got the approval, then they went out and bought the smart cottage. And so that was their reliance on the approval or the promise to approve, if we want to be, legal law students. And there was substantial reliance, and now there's damages, right? Because they've purchased this smart cottage in reliance on the approval. So just explain why that's not, I guess, a valid argument, valid claim.
Well, aside from never actually approving a mobile home, a manufactured home, just approving this floor plan, that's what was approved, because they couldn't have approved it. They didn't have the authority to do that. So as a party to the contract, Pryor couldn't have relied on that. He I believe this court in Vera versus North Star Dodge says, a party to a contract is held to know what words were used, know their meaning, and understand their legal effect. So whether he understood this procedure or not, he had, he was on notice, he's a party, that this couldn't have been done. But it's, aside the fact that there is nothing in this approval that references mobile home, prefabricated home. And even if the court accepts these arguments, there's no dispute that this proposed structure was not built in the same fashion as the site-built barn dominium. This barn dominium is beautiful, it's site-built, it's, but, and I don't think the association had any reason to believe that this was gonna be built any differently. That's why it was spelled out in the approval letter.
You have 1 minute left.
If the court doesn't have any further questions, I'll give up the remainder of my time.
Thank you. I don't have any. Thank you. Mr. Weber, you have 10 minutes.
May I proceed?
Yes, sir.
Appellant made several references during her argument about nothing was disclosed saying that this was a mobile home. Well, the reason for that, of course, is because the appellants had no idea that it was a mobile home. In fact, they were told that it wasn't. And so what this gets us into the question of is when we look at it, this is what was built. This is the type of structure that we're trying to avoid. We did avoid the type of structure we're trying to avoid. Counsel said, my learned friend said that the structure's floor plan was approved. Well, that's kind of interesting because let's just say that that floor plan that had been approved had been site built. And it resulted in a structure that looked like this diagram that's on the top of the easel. Would it be okay then? If it would have been, that reminds me of one of my favorite bits of Russian philosophy. It's called Korzybski's theorem. A difference which makes no difference is no difference. Does it really make that much of a difference that this was built off-site and brought onto the property? And that's not okay. But if the very same structure, the very same floor plan had been built, site built, like the barn dominium, then it's okay. That makes no sense to me. And what that does is it basically says that this, the RK1, isn't going to be allowed, despite the magnificence of that structure, which makes even less sense to me, simply because it's built off-site. This is the way that the technology of the construction industry is going for residential construction. It's a superior way to build a home. It's going to result in energy efficiency. It's going to result in saving of resources. And if we interpret these clauses to mean you can't bring it onto the property from someplace else, and that's the only thing that matters, then the RK1 can't come into the Overhill subdivision either.
Mr. Weber, let me ask you, in your brief, you state the association's approval of the smart cottage is actually a variance or a modification to allow said structure upon the property. But in your reply, you assert that as set forth in its brief, and as also pointed out below, Pryor did not consider a variance because it did not realize a smart cottage could or would be considered a mobile home. So my question is, do you view the association's approval as a variance or not?
I don't, Justice McCray. In fact, one of the comments that I made in my written notes was why would one need a variance if they already have received an approval? A variance would be for, here's where I typically see a variance being requested. Let's just say that the covenants say no removal of, that there's a certain setback required. And it just so happens that a century-old oak tree happens to be right where the house would have to be put in order to comply with the setback. Well, can you get a variance to go into the setback to allow the century oak tree to remain. That's where you're doing something against the covenants knowingly, and there's a good reason for it. And so a variance would be sought and either would be granted or not to go into that setback. If it's not granted, then some other accommodation needs to be made.
So if the smart home violates Article 2, Paragraph 1, and if you do not have a variance or you don't consider the approval to be a variance, how can you maintain any right to keep the smart home on the lot to the detriment of the other property owners in the association?
For two reasons, Justice McRae. First of all, because the approval of that structure, whatever we want to call it, was given. It was submitted, the floor plan was submitted. It's our position that subsequent elevations were provided, and that structure was permitted. Once again, you don't need a variance to get approval for something that's already been approved. It's approved ipso facto. The second reason would be because it's not the primary structure on the property. The primary structure, as Ms. Hughes indicated, is this stunning barn dominium. And these were to be ancillary buildings. And so it's not like we've got this, there were intended to be two of these smart cottages ultimately on the property so that the whole family could get together. But it's not like this was the primary structure on the property. This was an ancillary structure. And so it made sense that it isn't going to be built exactly the same proportions and materials and everything else as the primary structure.
Thank you.
Mr. Weber addressed for us, we know that a declaration is construed and interpreted. We use contract rules, right, of construction. Ms. Hughes tells us that the declaration's language that says they must be built and maintained in the same fashion as a single-family residence. Speak to that, how the association's approval is not approval because this didn't happen.
The structured issue, these are once again, I don't know what else you could use that for, but a single-family residence, unless it were built entirely hollow and maybe you used it for storage. I mean, clearly, this structure is intended to be a single-family residence. And once again, it was approved, at least it's undisputed, that the floor plan was approved. And so once again, if this structure had been site-built as a single-family residence, would the association then not have a problem with it, even though its appearance was otherwise identical? It's a distinction without a difference. We're fussing about the fact that it was built off-site, and that seems like the only thing we're fussing about. And that just doesn't make sense to me anymore, given the fact that we are not dealing with the first exhibit, the architecturally uninteresting mobile home. We're dealing with something that looks completely different, but just happens to have been constructed off-site. And that, I think, is a significant distinction and a significant difference.
How do you address the question of putting this this home on a foundation?
It's my understanding that these types of structures can be placed on a foundation, that a slab can be poured, and that they can be mounted on the slab. I'm not sure that that would have satisfied the association here because, once again, they seem to be hung up on the fact that it was primarily built someplace else and then brought in onto the property on wheels.
Wasn't there some discussion during the between the parties about this would be approved if it was put on a foundation?
There was. Unfortunately, those weren't able to be brought to fruition. There was some settlement discussions along those lines. If memory serves, I think the primary reason for that, or primary reasons, were the cost involved in pouring a slab that hadn't been anticipated. And then also, these structures are not designed to be moved around. They're designed to be constructed, put in place, and then left there. And to have elevated the structure and moved it someplace else to then pour that slab and then put the structure back on top of it probably would have damaged that structure, and that's why it couldn't be done.
Where did the court go wrong in granting the summary judgment?
I think primarily, Justice Meza, where the court went wrong was not giving any credence to the Estoppel issue at all. And that's, to me, that's the biggest issue here. Once that approval, in fact, the point I made in my notes here is, but if the homeowners association reviews the plans, shouldn't it have a duty to do so in a commercially reasonable manner? And then be bound by the determination that it makes? That's where we got off the rails here, I think, is it's clear that a review process, a protracted review process was undertaken. And despite that review process and despite that approval, that could, by a reasonable person, be understood to mean, hey, we can bring this smart cottage onto the property. They did that, they bought it, and then they were told afterwards, actually, no, you can't do that. And now we're being told, and not just today, but previously as well, that, well, it would be okay if it was built stick-built, which to me, again, seems to be a distinction without a significant difference, especially given modern residential construction techniques.
And it's your position when you first started or your argument this morning, is that you think the court erred in granting the association summary judgment, and you think it should be reversed and remanded so that it gets fleshed out in the trial court?
Yes, Justice Rios. I would suggest that if this court were to tell the trial court, hey, Estoppel does apply here, that the approval is something that the association should be bound by, and having given that approval, you need to evaluate the rest of the case in light of that. I think that would get the trial court set back on the right path. And then it could examine those issues about whether that approval was granted negligently. Am I seeing my
Your
time is up?
time is up.
Perfect timing.
Thank you very much. Your case is submitted, and we will notify you as soon as we have an opinion for you.
Thank you so much for
Thank
your
you.
attention.